Okay, we have big news in the Sophie Long case that developed right at the end of last week, and we have been covering that case despite the shrieking of several angry people on the internet and even some angry lawyers. And I will continue to talk about this case in the manner that I have approached the case the entire time, one that is relatively neutral. We're going based off of the facts that we have available and that are established, and we're talking about the legal proceedings that have been going on. With that said, let's talk about why the appeals court has rejected Michael's petition for a writ of mandamus and what this means going forward. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, hit like, subscribe, turn on your notifications, all of that stuff, okay? All right, here we go. This is from the Fifth Court of Appeals. It is a memorandum opinion. It is very short, flat out denying Michael Long's petition for writ of mandamus. How do we get here? I'll give you a very brief backstory. This is the Sophie Long case. This is about a little girl who alleged abuse from her mother's boyfriend, Jacob Bellington. Her mother's name is Kelly Long. This stems out of a custody dispute between Michael and Kelly Long following their divorce several years ago. Last year, this case rose to prominence with a viral video of Sophie protesting loudly and in a very distressed manner that she did not want to return to her mother's care because her mother and Jacob do things that make her uncomfortable and make her feel bad about it. It's a heart-wrenching video for just about anyone to watch. And early on in the case, people were largely in favor of Michael because of this video. But somewhere around September of last year and moving into this year, that started to change. And now public perception has shifted largely in favor of Kelly, who has employed not only the Routes and Law firm, but also the Red Banyan PR firm to help her manage the public side of this. And the employment of that PR firm is something that I've been slowly probing into and will hope to give you more information as that story develops. But the PR firm in play, along with some shifting court opinions, have shifted public perception against Michael, to the point where now the court and the public seem to be convinced that Michael is somehow involved in coaching Sophie into making the video against her mother. I have my doubts about that assertion, but we don't actually know what happened there. That is certainly a possibility. It's something called parental alienation. And the court right now is under the impression that Michael engaged in this parental alienation. Now, before anybody gets their undies in a bunch over this, on both sides, there are some real troubling issues that occurred at the May hearing in which this parental alienation was established. Those troubling issues involve the court not allowing Michael to enter testimony on his own behalf and making orders that seem to go along with Kelly's lawyers and infringed on the rights of Michael without appropriate due process. These were issues that he raised in his request for mandamus. Now, what a writ of mandamus is it's an upper court telling someone else, in this case, the lower court, that what they have done is damaging and needs to be undone immediately and cannot wait for appeal. I think Michael had a relatively decent shot at getting mandamus, but you have to understand getting one of those writs of mandamus is an extraordinary remedy, and it requires a huge showing by the person that damage will be immediate and that an abuse of discretion occurred. And I think that the appeals court has indicated that Michael did not appropriately argue the abuse of discretion standard for his petition for writ of mandamus. He is a pro se litigant, meaning he's representing himself, and this is a very complicated issue that requires accurate citations on it to show where the discretion was abused, and I think they have indicated that he did not adequately do that. While personally, I think maybe some more deference should be given to him because the issues all seem to imply an abuse of discretion, I will say that the mandamus petition itself didn't list out as thoroughly as it should. I guess that's what the court is saying. The specifics of the standard for abuse of discretion and how this particular fact pattern of decisions at the lower court levels fit into that. But let's take a look at this, and then we'll talk about the procedure of this and why this is a little bit shady. There are some shady things about this. We do have to put that out there, and you know, there seems to be something going on in Collin County, but you know, here's what we've got. This is the system we're with. So in this petition for writ of mandamus, relator, that's Michael, challenges the trial judge's temporary orders in the underlying suit against the parent-child relationship and the order denying relator's motion to recuse the trial judge from the modification proceeding. It's not just recuse. It was motion to recuse and disqualify. And the argument on the disqualification was actually better than the argument on the motion to recuse, but maybe they just truncated it for this opinion that they issued in 2 hours on over 100 pages of submitted documents. Entitlement to mandamus relief requires relator to show that the trial court has clearly abused its discretion and that relator has no adequate appellate remedy. After reviewing the petition and record, we conclude that relator has failed to show an abuse of discretion. Accordingly, we deny mandamus relief, and then we also deny relator's motion for emergency relief as moot. If there is no pending mandamus, there is no motion for emergency relief necessary. Now, can Michael redo this? Maybe. He has like 1 day to redo it. I don't know if that is in the cards, but he's got like 1 day to get this thing up there and move for an emergency stay again, this time fleshing out the argument that there was an abuse of discretion more thoroughly, I guess. Maybe opening with that section would be really, really important. Introduction, bam, abuse of discretion standard. And this is part of legal writing. It's how you write everything. IRAC format is intro, rule, argument, conclusion, and hitting the rule and clearly stating the rule and then arguing about the rule is critical to how you construct a legal document. So it looks like the Court of Appeals was dissatisfied with his argument on the abuse of discretion standard here. Now, where the drama comes in on this is that Michael had originally submitted his petition for writ of mandamus and his petition for his motion for an emergency stay, and the court had already rejected that. They said no because it contained sensitive data. They said there's too much sensitive information in here. You have to refile it. They gave him until July 30th to refile. He refiled on July 29th. To refile this, he had to bring in two physical copies to the courthouse that were bound and to file them in person. He did this. This was, well, I don't know if he did it personally, but they were delivered to the court. Those physical copies were delivered. And then within 2 hours, this rejection came back down. So some people have questions about whether or not they appropriately reviewed the documents. Again, this is well over 100 pages of document, but it seems like they focused entirely on a lack of properly arguing the abuse of discretion standard. And this is where having a lawyer who is skilled at doing these sort of things really, really helps, and where a lot of lay people run into trouble on these issues, because petitioning for writ of mandamus being such an exclusive and rare remedy requires the utmost care in crafting the request. And the court, again, has said that it wasn't good enough. That's the evidence that we have that it wasn't good enough, is that the court said so. So in this case, Michael is not going to have any relief prior to the August 4th hearing unless he were to somehow able to get that section in there and refile it, you know, today or tomorrow and get that emergency order. Doesn't seem very likely that that would happen, but it is in theory possible. I don't know if Michael is planning that. I have no idea. I don't have any contact with him or anything like that to verify that, but that is where this stands at present. It looks like the August 4th hearing is going to go forward. There will be some real questions. Michael will likely have to produce Sophie at that hearing. And if he does not, which he may decide not to, he may be jailed for contempt of court. And then there could be some real questions as to what happens next. But that is the big update in the Sophie Long case. As it stands right now, I will be attempting to cover the hearing on the 4th, probably after the hearing takes place, getting as much information as possible about it. And we will continue following this story, no matter how many false privacy complaints I get, and no matter how much the other lawyer doesn't want me to. We will continue to watch and see how this turns out. Thanks for watching. Until next time, peace. Peace.